everybody. I should note that since these bios were created, both David and I and others have been blacklisted by China, so we can add that to our list of awards, as I often now do. In any case, it's an honor to speak with you all today. I'm going to cover some of the mechanisms that the international community has established to pursue justice, accountability, and the rule of law, particularly in the face of grave crimes that threaten our collective humanity. We live in a world where unimaginable acts, including genocide, continue to occur. But amidst the darkness, we also witness the persistent efforts to bring perpetrators to justice and uphold the dignity of victims. So today, I will walk you through the pivotal roles of two international courts, the International Criminal Court, or ICC, and the International Court of Justice, ICJ, as well as the importance of ad hoc mechanisms, people's tribunals, and civil society in this global pursuit of accountability. Let's begin with the International Criminal Court, or the ICC. This is the world's only permanent international court tasked with investigating and prosecuting individuals accused of committing the gravest offenses, namely genocide, war crimes, crimes against humanity, and in some instances, the crime of aggression. Established under the Rome Statute, which entered into force in July 2002, the ICC operates on the principle of individual criminal responsibility. So as David covered, it does not try countries or governments as a whole. It prosecutes individuals who bear the greatest responsibility for egregious violations. The journey of a case before the ICC follows a particular pathway. It begins with a preliminary examination into a so-called situation. This is a region or a conflict where crimes may have occurred. And then if sufficient evidence exists, this proceeds to a full investigation, followed by the issuing of arrest warrants and potentially the prosecution of specific individuals. But how does a situation reach the ICC? There are essentially three avenues. One avenue is the prosecutor can initiate an investigation on his own initiative. This is proprio motu. A second is a state party to the Rome Statute can refer a case to the court. The third is for the United Nations Security Council to refer a situation, and this can happen regardless of whether the state in question is a party to the Rome Statute or not. For all non-UN Security Council referrals, the ICC's jurisdiction is limited by some essential rules. First off, the crimes must have occurred either on the territory of a state party to the Rome Statute or may have been committed by state party nationals, and they must have taken place after the statute came into effect for the particular state or after the state in question accepted the ICC's jurisdiction retroactively under Article 12. Additionally, the court operates under guiding principles. It focuses on those most responsible and the principle of complementarity, meaning that the ICC only steps in if national jurisdictions are unwilling or unable to prosecute. The ICC also faces many challenges. Political pressure, lack of cooperation from states, limited resources, and accusations of bias have all tested the court's legitimacy. Enforcement of arrest warrants in particular remains a significant hurdle, since the ICC lacks its own police force and must rely on state cooperation. Despite these limitations, the court's existence has changed the landscape of international justice, setting a clear legal standard that great crimes will not go unpunished. While the ICC is a judicial body, its ability to function effectively often relies on the work of civil society. Civil society organizations, or CSOs, are frequently the first to document atrocities, support victims, and mobilize public will for justice. There are several ways civil society can engage the ICC. The first is by submitting an Article 15 communication. This is a formal request urging the prosecutor to open a preliminary examination on his own initiative. It should lay out the facts suggesting that crimes within the court's jurisdiction have occurred, namely genocide, crimes against humanity, or war crimes. And these submissions should also address questions of jurisdiction and admissibility, including whether the crimes are sufficiently grave and whether the national systems are failing to act. Second, CSOs can advocate for a state party to refer a situation to the ICC. This can involve private lobbying or public campaigns. Alternatively, they can push members of the UN Security Council to initiate a referral, especially when jurisdictional limits prevent the ICC from acting. Third, if a preliminary examination or investigation is already underway into a relevant situation, civil society can submit supplemental evidence, and this can be done via a form that's readily available on the ICC website. This need not be as detailed as an Article 15 communication, but it must still be relevant and credible. Fourth, and finally, in some cases, civil society can submit amicus curiae briefs. These are friend of the court submissions that provide legal, policy, or contextual analysis. Though the acceptance rate for such briefs is relatively low, they can still play an influential role in shaping proceedings or public understanding. Now let us turn to the International Court of Justice, or the ICJ, which is the principal judicial organ of the United Nations. The ICJ serves a different function from the ICC. It does not prosecute individuals. Instead, it settles legal disputes between states and issues advisory opinions on questions referred to it by authorized UN bodies. In contentious cases, meaning disputes between states, only nations may appear before the ICJ. Importantly, jurisdiction is essentially based on consent. States must agree to bring the matter before the court, whether this is through a treaty that contains a clause saying that they'll accept the jurisdiction of the court, as exists in the Genocide Convention, or it can be by special agreements between states, or if a state has recognized the court's compulsory jurisdiction under Article 36 of the ICJ statute. Unlike the ICC's focus on individual criminal liability, ICJ proceedings emphasize civil liability, addressing the responsibility of states for breaches of international law, including, as I mentioned, violations of the Genocide Convention. When one state brings another before the ICJ, the court does not hold a criminal trial. Instead, it assesses the behavior of the state itself, examining whether legal obligations under international treaties have been violated, and then what remedies, such as declarations or reparations, are appropriate under international law. In advisory proceedings, organs such as the UN General Assembly or the Security Council may request the court's opinion on legal matters. While not legally binding, these opinions carry significant weight in the development of international law. Unlike at the ICC, civil society cannot directly participate in ICJ proceedings. However, CSOs can and often do still play a critical behind-the-scenes role, lobbying governments to initiate cases, conducting legal research, and sharing data or analysis that states can incorporate into their official submissions. In fact, civil society has successfully helped bring cases before the ICJ, often by securing political commitments from sympathetic parties during election cycles or times of governmental transition. In recent years, the ICJ has handled several high-profile cases, and I know Professor Packer has already covered this, including disputes concerning genocide allegations, territorial conflicts, and environmental harms as well. For instance, the Gambia's case against Myanmar for a genocide against the Rohingya population global attention, and these proceedings demonstrates the court's role not just in dispute resolution, but in interpreting and reinforcing core principles of international law. In addition to the ICC and the ICJ, the international community has established ad hoc mechanisms to address specific crises or historical atrocities. These include international and hybrid tribunals such as the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda and the extraordinary chambers in the courts of Cambodia. These courts were created to bring justice where no other forum existed. But more recently, the UN has trended towards developing non-prosecution mechanisms focused on evidence collection and case preparation instead, such as the International Impartial and Independent Mechanism for Syria, IIIM, the Investigative Mechanism for Myanmar, the Sri Lanka Accountability Project is another one. These entities generally work to preserve evidence of atrocities and prepare case files that can then be used by national or international courts when the time for prosecution rises. And here again, civil society is indispensable in these efforts. Often operating in places where international actors cannot reach, civil society groups provide on-the-ground documentation, witness support, and local knowledge. These mechanisms rely heavily on their partnerships with civil society in order to function effectively. In situations where formal mechanisms fall short or where no official avenues exist, civil society also has created its own mechanisms in the form of people's tribunals. These are independent forums convened to investigate and publicly adjudicate alleged international crimes. One of the most enduring is the Permanent People's Tribunal, which was founded in 1979 and has held more than 50 sessions on issues ranging from war crimes and genocide to ecological and economic crimes. Again, while its findings are non-binding, the tribunal's work serves to recognize victims, record their experiences, and keep international attention focused on forgotten or ignored atrocities. Other examples include the China Tribunal and the Uyghur Tribunal, both of which investigated allegations of crimes against humanity and genocide against Falun Gong practitioners and Uyghurs, respectively. Though these findings, again, are not enforceable in a legal sense, they have significantly influenced public discourse, informed advocacy efforts, and strengthened additional accountability measures. I know David and I alone have referenced the Uyghur Tribunal finding and numerous submissions that we've done over the last couple of years. So in this sense, they can be really significant. Launching a People's Tribunal does require significant effort, coordination, and credibility, but as I said, the impact can be quite profound. These forums give a voice to communities seeking justice, especially when other avenues are closed. At every stage of the international accountability process, from initiating cases to gathering evidence, from advocacy to analysis, civil society plays a vital role. These actors do not merely support the system from the outside. In many ways, they are the beating heart of international justice. They shine light in dark places, push reluctant institutions into action, and insist that the world remembers its promise to victims of genocide and other atrocity crimes. Whether they are drafting Article 15 communications, lobbying for state referrals, gathering survivor testimony, or launching people's tribunals, civil society organizations are the guardians of justice in times when institutions falter or fail. And when I say they, I do mean all of you. Justice is not automatic. It demands effort, persistence, and often courage. Whether you are a lawyer, an activist, a policymaker, or just an engaged citizen, you have a role to play. Supporting the institutions that hold perpetrators accountable. Fund organizations that document crimes, share the stories of survivors, and advocate. Because justice doesn't just happen in courtrooms, it happens when we collectively insist that the law must prevail over impunity. In closing, let us remember that the pursuit of justice is not the task of any one institution. It is a shared endeavor, a global mosaic of courts, tribunals, advocates, investigators, and survivors. The ICC and the ICJ offer formal routes for accountability. Ad hoc mechanisms may preserve evidence and support future prosecutions. People's tribunals give voice to the voiceless. And all of you, all of civil society, ties them all together, ensuring that justice is not only pursued, but seen, heard, and remembered. We must continue to strengthen these systems. We must hold them accountable, even as they hold others accountable. And we must never forget that justice, while slow, remains a powerful force for dignity, truth, and peace. Thank you.